have an unruly setting. Second one is that in addition to what they get in the faculties of education, regular in-service that deals with issues like bullying, cyberbullying, inclusion, and so on, so that the ongoing education needs to be provided as well. Roles of the justice system, next slide, and safe and inclusive schools. Fortunately, because I know time is marching on here, is that the inclusion issue was certainly covered extensively in the panel that I chaired on the legal view on education inclusion, and I'm sure was touched on from an international perspective as well. But obviously there is now an important legal component to issues of inclusion, both under, well, as they list here, Charter, the Education Acts themselves, human rights codes, a lot of human rights cases, Charter of Rights, and Section 15, so that in recent years, and my colleague Diane Potier and Judy Henteloff and Dr. Snodden in our session talked about the extent to which now legal challenges are really starting to shape the way in which schools practice. And the Moore case from British Columbia will be a big and important decision decided sometime probably in the next 6 months to a year on the extent to which schools can do that. So what I put here is inclusion and the equality imperative. That my position in a number of things I've written and others as well is that in order to achieve equality, you do have to have inclusive schools. We then have big debates about what's inclusive and what's effective inclusion. That's a big debate, obviously, and who gets to decide that. But at least on the principle that the constitutional and human rights codes mandate that we must treat people equally, in my view, requires and mandates inclusive education. Defined properly. So anyway, that's a large area. And the next slide, and I'm just going to very briefly touch on this in the hope of leaving more question time, a number of important cases that have dealt with this. One that I'll come back to in a moment, the Malcolm Ross case from the Supreme Court of Canada, which talks about the role of school boards generally to effectively provide discrimination-free zones. So you kind of think of those big red signs with a red line through it that no discrimination here, and we'll come back to that. The Eaton case, which was one of the few directly dealing with the balance between inclusion or mainstreaming on the one hand, but meeting the best interest and individual needs of particular students, and saying there isn't a presumption of mainstreaming. And I don't have time to get into this, but terminology is quite important, that inclusion is more than mainstreaming and all these kind of things we could get into. But Eaton is a very clear statement, in some respects at least, from the Supreme Court of Canada on that point. The Weinberg case in Ontario concerned autistic children and the extent to which the schools and school boards could be provided to provide what appears to be fairly effective but high-cost interventions for autistic children in terms of intensive therapy, which was in the earlier cases, or I guess in the final case, not accepted, but perhaps should be. It's that difficult question, even if it costs a lot. If this is the best way to educate a child, then do we have some equality obligation to do that? So that's a big issue as well. And the Moore case, as I mentioned earlier, a dyslexic child with learning disabilities and dyslexia needs not being met or allegedly not being met in the public school system, and whether or not the school had discharged its duties. And again, in our last session, this was dealt with in much more detail, but one of the questions being, do they have a right to special education or do they have a right to education? And what does that mean in terms of accommodation? So that's going to be a very big case. On the next slide, just as a sort of anchor to the important potential role for courts in this area, is the Laforêt from New Brunswick, his decision in the Ross case, saying that school is an arena for the exchange of ideas and must therefore be premised upon principles of tolerance and impartiality, so that all persons within the school environment I guess I fell, but they may fall, but I guess we mean feel equally free to participate. As the Board of Inquiry stated, a school board has a duty to maintain a positive school environment for all persons served by it. Now, that's a really strong statement for advocates of human rights in schools, because they're not just saying you shouldn't discriminate, but you have a positive obligation to maintain a positive school environment. And again, clearly links to questions of school violence as well as inclusion. You know, how can you have a positive school environment or climate if you haven't dealt with issues of bullying and cyberbullying? How can you have a positive school environment if you're not accommodating and responding to the diverse needs of the students in your class? So that's a really strong statement from the top court in the land as a majority statement, saying there's a positive duty on boards to do that. So I think that's worth noting. Next one, on some of the writing I've done, I guess showing my maritime roots, I talk about the lighthouse of equality and make the probably contested view, especially for the educators among you, that lawyers are a source of light rather than fog. And I'm sure if I did a poll, most of them have dealt with lawyers, say they create the fog, not the light and clarity, and we're trying to provide the clarity and the lawyers produce the fog. I'll leave that debate for discussion or whatever, but my premise for sort of metaphorical purposes is that in organizing how schools operate, that the concept of equality should be a kind of guidance like a lighthouse to how we do it. And in two ways, individual discrimination, that we should avoid individual discrimination and accommodate individually, but also systemic. And as the little quote, which I won't read there from my piece, says, we've been more effective and more clear, I think, in stating the demands of individual accommodation. We still have a long way to go on the broader systemic changes that need to happen. What are the institutional changes that need to happen to be really inclusive? How do we create barrier-free schools? How do we create universal design, as various people talked about yesterday? Those systemic issues are huge, and the courts are only really starting to address that, but it is both. Next slide is the key concept in terms of human rights codes of reasonable accommodation. There's, as the second statement says, there's no absolute right to accommodation. Our human rights codes say you have the right to be accommodated, have your difference taken into account, but only up to the point of undue hardship. So that if the effect was to bankrupt you or put you out of business or so on, you didn't necessarily have to do that. But the courts have been pretty clear, Supreme Court of Canada and others, in saying it's a pretty high standard to meet. That in order to establish that you have reasonably accommodated, it's not enough that there's going to be some cost, or it's not enough that there's some disruption. You have to really demonstrate that it would be unreasonable or cause undue hardship to do that. And Justice McLaughlin commenting about the broader point that accommodation of diversity shouldn't be grudgingly done, but celebrated. And I think this conference, in a way, is a good testimony to that. And last night's kickoff is a perfect illustration of that, that having diversity and accommodating and including people in the broader tent, if you like, is a positive thing to be celebrated, not something that we have to put up with and pay money for. So we may have to pay money, but we get a lot of benefits out of that inclusion. It's not about benefiting just those who are being included. It's about benefiting the rest of us to having the wisdom and insight of those that we now include. And as part of the New Brunswick study, we did a field trip to Finland, which is a fun field trip, which had a very good education system. And in that one of the things that they emphasize, I think, is that the benefits of inclusion should start early. And again, I applaud New Brunswick for their new early childhood strategies and so on, that these are things that should start in preschools and so on. Okay, next slide. Just some of the many factors for the non-lawyers among you, and there's lots more, but factors related to what is reasonable accommodation, the cost. Now, again, one has to be cautious with that. Our charter doesn't say you have the right to equality unless it costs too much. But on the other hand, we do have to recognize that there are financial realities, and school boards and others have limited resources, so cost is a factor. Health and safety. Obviously, if there's health and safety questions, that arises. Size of the operation is important. Large, relatively well-funded or deep public pockets, government agencies are going to have a tougher time making a cost defense than a small mom-and-pop store, for example. And other reasonable alternatives. Are there other ways to achieve your objectives without discriminating? So, and reasonable limits under the Charter, I don't have time to get into that, but that's a bit broader concept as well. But like in human rights codes, while we have a broad guarantee of rights, Section 1 of the Charter says all rights are subject to reasonable limits in a free and democratic society. So that then the debate is, what are the reasonable limits? Okay, next slide. Safe schools. Criminal code, as I'll get to in a moment, this is the role of law in this. Lawsuits such as negligence and defamation, constitutional limits, human rights, and restorative approaches. And I'm getting close to the end here. First of all, in terms of the criminal code, I think really important to say that the more important response, although you have to do both, or you have to do all of it, is trying to reintegrate and prevent and be proactive. That only in the more extreme cases should we have to invoke the ultimate criminal sanction, but there are times. And for example, the case I mentioned earlier about the young man going on Facebook claiming credit for convincing 3 young women to commit suicide and continuing his and his group's project in that regard, to me, maybe that's something that needs a criminal sanction. But it's the more extreme case that does. There are some provisions that we talk about in the report that already could reach that, assault in some cases, in terms of real bullying, obviously, criminal harassment, uttering threats, and other kinds of provisions, intimidation, are all sections in the criminal code that I think could be currently used, although there's a reluctance to do so. And these definitions in the criminal code apply to everyone. Just a quick nod to the Youth Criminal Justice Act, next slide there, is that between 12 and 17, the criminal code substance provisions still apply, but a different process and different penalties, but much debated, is it strong enough, is it not strong enough, whatever, apply, and some additional rights are there. But the criminal code does apply to young people as well as adults. And another point that I often mention in these kind of settings is that contrary to the view of some principal students, there's no dome of immunity over the schools. The criminal code applies to the schools. And it's dangerous for people to, principals and others, to say, well, we'll just handle it internally because the criminal code applies everywhere. Question, the next slide, is just a crime of cyberbullying. And I'm not coming down on one side or the other of that. I think there's quite a bit of possibility within the existing criminal code provisions. But if police and others feel that's not the case, and this is a provincial task force, so I just suggested that the provincial minister talk to the federal people who do criminal law about whether there should be a separate criminal offense of cyberbullying for extreme cases, and we can have that discussion. The next slide is negligence, and this is quite an interesting one from a legal point of view, because the general rule about negligence is, as it says, failure to execute a legal duty in a reasonable way, and the general, to put it really simply, is if there's a foreseeable risk, then you should do something about that. And given the statistics and information that we have about bullying and cyberbullying, it's absolutely foreseeable that in your school there will be bullying and cyberbullying. So what is your obligation to then respond to that? And we had presenters before the task force that were saying it's an important message. We should start having lawsuits, that the only way you're going to get the attention of school boards is to have lawsuits with big damage claims, and then you'll really get the attention and they'll start doing something because it's costing too much. Now, again, we can have that debate, but whether or not that's correct, there are increasing numbers of lawsuits about not properly protecting students from bullying, cyberbullying, abuse, and so on. And we'll come to one more in a moment. Next slide is on defamation, and this applies either on, but particularly online, if you're attacking someone's reputation. And this can be students commenting about teachers, students commenting about other teachers, or not that I recommend this, but if anybody's ever looked out thedirty.com, and as I say, I'm not recommending this, but if you ever do go and Google thedirty.com, what it is the group, a company, I guess, who gets pictures either sent by other people or off Facebooks and so on, and then encourage all kinds of people to write in with nasty and hateful comments about these people, very homophobic, very sexist, and they identify not just by picture, they put the name and location, and it's by town. So for example, in this case, and my guess is, as I say, you might, for those who are connected to the world here, if you go on thedirty.com and look for Fredericton, my guess is there will be a list of people from Fredericton who may or may not know that they're on this site with all kinds of people making outrageous allegations and usually scantily clad pictures and all that sort of thing. So anyway, that kind of thing may get into, one would think, questions of defamation, assuming the comments they're making are not correct. From a legal point of view, the second bullet here, the Bragg Communications or Eastlink case is currently on appeal to the Supreme Court. A young woman who was cyberbullied on Facebook wanted to take a claim of defamation, but was wanted to remain anonymous, the AB, that her name is not known, and didn't want the negative and hurtful comments on Facebook repeated. So she went to all the way to the Nova Scotia Court of Appeal and lost to say, I want to pursue a defamation claim, but I want a ban on the courtroom, and I want to not have my name identified. And at this point, the Nova Scotia Court of Appeal said, you can't do that. If you want to do a defamation suit, it needs to be an open court, and you need to identify your name. And that's now, the Supreme Court of Canada will give us some guidance on that one. So that'll be interesting, because obviously it'd be a disincentive to defamation lawsuits if you have to relive all the negative comment and damage to your reputation. So finally, or not finally, but on this one, constitutional limits. One of the areas, and I teach and Diana, others have taught, is constitutional law, and UD is very aware of that as well. Put some limits, as they should, on what can be done, even in the name of a good cause. First of all, you have to fit within division of powers. The province can only do things within its jurisdiction, and it has a broad education jurisdiction under Section 93. The federal government can only do things within its jurisdiction, such as criminal law, communications, and so on. So that's one limitation, but perhaps more significantly, the Charter of Rights, which now says that in whatever you do, you should not be violating privacy, although that's a bit trickier debate, but for today's simple version, free speech, which is a huge limitation. Remember the guy who was bragging about convincing these young women to commit suicide said, well, they're just words. You can't do anything. I'm free speech. I can do what I want. And one example, an American, high-profile American example from the U.S. Supreme Court, Brown versus Entertainment Merchants Association. And just before we get to the next slide, the majority, this was a case where they were trying to ban the selling of violent video games to 13-year-olds and younger. And these violent video games were really violent, like murder, torture, rape, and so on. And they, forget which state it was exactly, did ban it and went to the U.S. Supreme Court, and they said, no, you can't do that, free speech. And one of the things they argued, and of course there was debating experts on this, does that kind of violent video game cause real life violence or not? And the majority said there's not enough link of a cause and effect between violent video games and violent action. Now others, experts on the other side, said the opposite. Well, of course, if you're desensitizing and making people, allowing people online to do these things, that it's going to promote violence. Now the next slide, there's a strong dissent, which is kind of put the issue quite well, I think, and this is from Justice Breyer. He says, but what sense does it make to forbid selling a 13-year-old boy a magazine with an image of a nude woman while protecting a sale to that 13-year-old of an interactive video game in which he actively but virtually binds and gags the woman, then tortures and kills her? What kind of First Amendment would permit the government to protect children by restricting sales of that extremely violent video game only when the woman, bound, gagged, tortured, and killed, is also topless? Which is one of those interesting broad issues. You know, is nudity actually a greater threat to our society than violence? I don't personally think it is, and I imagine a lot of others wouldn't. But oddly enough, as the dissent is pointing out, that the nudity would be acceptable limitations on U.S. free speech, but violent video games would not. And be interesting what the Canadian approach on a similar issue would be, and lots of big issues there. All right, next one, and I'm already over my 45 here. Human rights. Obviously, human rights commissions have an important role to play, and I mentioned earlier that Australia and others have done that, so skipping over that. One of the attractions for human rights responses is a lot of different options as to how you proceed. Education, mediation, complaint, the restorative approaches, and they're more accessible. You don't have to hire a lawyer and pay multi-thousands to go to court. Next slide is one very interesting example of that from BC Court of Appeal, the Gibran case, in which a young man had been bullied on homophobic grounds throughout his whole junior high, I think 3 or 4 years. And it went all the way to the BC Court of Appeal, and the schools did what most do on this. They suspended the bullies, and then they'd come back and either they would do it again or new people would do it. But the court, in a pretty, again, impressive decision, and one that gives real scope for advocates, said that there's a duty on the school board to effectively respond to bullying. And since suspending wasn't doing it, they should have been educating people about homophobia. They should have been engaging in preventive strategies and assessed a fairly large cost award against the school board for not properly dealing with this. A little side issue, which I shouldn't get into, but in the earlier case, because Mr. Gibran claimed he wasn't gay, which he might or might not, doesn't matter. But the earlier cases at the trial level said, well, if he's not gay, then there's no violation of the Human Rights Code, because it only covers you if you're gay. But if you're perceived gay, then code doesn't cover. Wisely enough, I think the BC Court feels, no. If you're either gay or perceived to be gay or perceived to be black or perceived whatever, surely that's a discrimination as well. So they did clear that up. But next slide, restorative approaches. And I guess I won't read through those, but basically a promising response, which in some ways goes back to Aboriginal roots of talking circles and circle sessions about sentencing and so on, to try to reintegrate them back into the community, have them there with the victim, the bully, but others in a safe setting, and try to do that, largely run by students. And we had amazing presentations before the task force of young people who did this kind of restorative approach with great success. The statistics were very impressive that schools, and there are a number in Nova Scotia which do this, that had discipline situations decline immensely, suspensions reduced, less violence, and what they did, which is a kind of an inclusive question in itself, they didn't just use these sort of circles and other things for discipline, but that's how they operated the class. That I sat in on some of these, the teacher would be there, the students would be all seated in a circle, and the circle is just one vehicle. But then they would be saying, well, you know, what topic should we cover for tomorrow of these 5? And everybody would, in a kind of talking circle way, get a chance to express their views, and they'd come to some decision and move on. So a kind of democratic, sort of less centralized approach. So interesting ideas, I think. Lots of legislation on bullying and cyberbullying. I think I'm going to skip over this very quickly. A number of provinces, Nova Scotia now has some, New Brunswick, quite good legislation, Ontario, Quebec has some as well. Theirs is a bit more punitive. They fine school boards if they don't properly execute bullying and cyberbullying policies. They have a fine if the school board doesn't properly deliver. Others don't do that. But anyway, and I have a list, which again in the slides you can look at, of what other provinces are doing with all kinds of models. The BC model, not to go by law and policy at all, but they put a lot of money into, I think, $2 billion or something, or $2 million, I presume, into actually responding. So there's a range of options. Next slide, which I guess will take us to next several slides. Accountability, right, thank you. In real terms, obviously, you can have whatever policies and rules and laws you want, but it only gets implemented if somebody's accountable. And in that regard, there's a lot of people that we need to make accountable: parents for supervising their children, schools and teachers, police officers, and so on. But I think the channels of accountability are really important, and we need to get to a point where the victims and their parents aren't sort of passed from one agency to the other saying, not our thing, somebody else's problem. So we need to really think about those questions of accountability. Next one, and you can take heart, it says concluding, so I must be getting close, right? Concluding thoughts, inclusion benefits all, obviously. Invest up front, pay now or pay later. And again, I was impressed that the New Brunswick Minister of Education is putting money into this, and that's great. Financial supports and human supports. And my general thesis, I suppose, throughout this presentation, proper inclusive schooling is the best antidote to bullying. That all kinds of other good reasons to have inclusive schooling. But in terms of bullying, cyberbullying, school violence, I think having a respectful, empathetic, inclusive school environment is probably the best, one of the best, if not the best response. And next slide. Thus, safe and inclusive schools are expensive, but not nearly as expensive as not nearly as expensive in failing to invest in the quality education of our children. The tragic human cost of not ensuring that our schools and universities are safe places to learn are revealed by Columbine, Tabor, Alberta, and more recently Virginia Tech. Now, again, extremes, but obviously you can't really have an effective educational setting if it's not a safe place. You know, how can, and that's partly, again, links obviously to inclusion. If it's not a safe place where you belong and can do what you're supposed to do in schools, then that's not going to be effective. So then I think this is, and yes, it is the actual final slide. Well, when my report, shortly after my report came out, and I probably unfair to Minister of Education Janix from Nova Scotia, I have this one here, but she was, at least initially, she came around on them, but resisted some of the recommendations. So the Halifax Herald cartoonist had a picture of her, the woman, bullying me as opposed to responding to the report. So I'm sure she didn't really do that, but at least she didn't do it effectively. The final little reference on that, and again, you'll have these slides, is there is a website called cyberbullying.novascotia.ca, and if you go to that, there's all kinds of information there, but including a full copy of my report and the appendices and so on, which you can download for free. So anybody that wants to look at the report and other things, just go to that website and it's there. So thank you very much for your patience, and sorry I went so long. So. So we're open, I'm open for questions, so if anybody wants to, and I guess, yes, there's mics. I guess if you could go to a mic and I'll try to respond.
Hi, I have a question. Going back to the very beginning of your presentation where you talked about your survey that you did, it was very interesting information. I'm just wondering, when you ask parents and students and such to answer the survey, especially relevant to bullying and have you been bullied, the numbers were quite high. Was there any kind of definition given to bullying? Because I'm thinking as a student, if you say, have you ever received a bullying email, and most of them were physical appearance or on your sexual status, whatever, I'm thinking as a student, if anyone ever sent me an email that said, you know, you redheaded whatever, that I'm going to take that as bullying. So was there any clear definition of what bullying was and not necessarily just a one-time thing or a conflict kind of situation?
That's a really excellent question. I'm glad you asked that. And the answer is yes, there was. And one of the early recommendations in our report is that, and I think this is going to be done through policy, is to adopt a accepted, consistently applied definition of bullying, which among other things includes normally, although not exclusively, repeated activity, normally but not always, a power imbalance, and so on. So yes, they were whether they followed it, the people facilitating the focus group said, here's the definition now, and put it up on the PowerPoint, and then said, now, in light of that. Now, having said that, it's a really important point, because when I was director at the Human Rights Commission, if you asked, let's say, young women in schools, have you been sexually harassed? They'd say, oh, no, I haven't been sexually harassed. Well, you know, people grab my behind and they sort of rub up against me, but that's just normal. That's not harassment, or whatever. So obviously, people will define it in very different ways. Other people might, as you suggested, see very small things as bullying or cyberbullying. So there was an attempt to have them apply a definition.
Thank
you. Any other questions?
I just want to throw one out while the other person may be getting to the mic, and you can repeat the question for the translators.
Okay.
Just wondering if you could give some clarification to the way to provide accountability to individuals using social media, but hiding behind the defense of free speech, but doing and saying things that obviously, in the opinion of a reasonable person, I would think could be clearly said to have crossed the line. But it seems to me that we don't have very strong tools at this point to really hold people accountable, especially when they're posting anonymously and yet saying some pretty direct and terrible things, and not just in terms of cyberbullying in the school, but even if you look at mainstream media websites and the postings that go on in terms of commentary, it is extremely upsetting sometimes to see what people post on there without any sense that they'll be held accountable for what they say.
Really important question, and try to recapitulate briefly for the translators that how do you make anonymous online bulliers and people making defamatory and negative comments accountable? How do we do that? And it's a really tough question, and it's really a balancing act, as so often in the law, that there's a right to free speech, but it's not an absolute right. And that's the key, right? That there are reasonable limits on free speech. So we already recognize through the criminal code that hate speech, criminal hate speech, is not free, is a reasonable limit on free speech. We used to recognize federally that hate speech as a matter of discrimination was also not acceptable. That was just repealed a few days ago, so we now no longer have a hate speech provision in the Canadian Human Rights Act. But there are other limits like that. Defamation. Defamation is not protected by free speech. So I think and I guess the only final point why this is so complicated, there's arguments, and good ones I suppose, that part of privacy rights and free speech is the right to anonymity. The argument is made, well, I have a right to be anonymous. And often the internet service providers will largely defend that because they're obviously going to be more likely to get customers if they guarantee you can do this in certain settings anyway, anonymously. So for example, thedirty.com, most of the comments, if not all of the negative comments, are anonymous. So then coming to your question, I think that the way I think to proceed is to have brave legislators, policymakers, and others draw a line and say, we think this is beyond reasonable free speech and we're penalizing it, and put the ball into their court to then come to court and say, but that violates free speech. Because the courts aren't going to make any statement till somebody triggers them. So that I think, and this is easy for me to say, but I think schools, police, and others need to be a bit bolder in taking this on and put the burden on those that they're trying to make accountable to use the free speech argument as a defense. Now, there has to be free speech. I'm not against free speech, but it is a balancing act. And I think at the moment, I think a lot of people are assuming, well, we can't do anything. It's free speech, so there's no point even trying. So that's a partial answer.
Well, the only supplement I would make to that, it just seems that there's a different standard to what's allowable as free speech on social media and the internet compared to the same statements if they were published in the mainstream media would immediately have repercussions.
No, that's a really, I think you're right about that. That lot more seems to be, in practical terms, tolerated on social media than you would in others. But the reality, the cases, there's an increasing number of successful defamation cases where defamation does occur online. And the courts, rightly, I think, have said, actually, it's more serious to defame online because you're reaching a huge and perhaps permanent audience. It's one thing for somebody to call you a name in the schoolyard and that's the end of it. Maybe a few people were there will remember it. It's another thing to have it up on YouTube that here for all the world to see forever is what you've said. So when it does go to court, the courts are increasingly recognizing this is actually a more serious injury. So I agree with you that the reality is greater toleration, but when it gets to the courts, they're actually somewhat less tolerant, saying, look, this is a really damaging thing, and it's by definition repeated. That's the other thing. Bullying and cyberbullying normally is repeated, but in some ways, if you put something on the internet, almost by definition, it's repeated. Certainly if somebody likes it or whatever, it's repeated. So I think the law needs to catch up with the reality and recognize that there's a bigger damage, and therefore more has to be done.
I want to pick up on the question of privacy.
Sorry, could I bother you just to go to the mic? Sorry about that, but then I don't have to repeat it. So.
I want to pick up on the question of privacy. As you know, we don't have any hierarchy of rights in Canada. And I'm a little concerned about some of the suggestions. For example, if a principal has the belief that, or staff has the belief that, without the necessity, of course, of having supportive evidence to that degree. So we have competing rights here: the right to privacy, the right to free speech, and free speech has no predominance in our country, as is the case with the United States. So I'm deeply worried that there may be an overreaction which invades other important rights, such as the right to privacy, by the concern about cyberbullying. And so I think we have to achieve it. And you've just hit upon it. What you said was the courts have to catch up. Well, why not give them an opportunity to catch up before we invade civil liberty to the point that we're invading other rights to the extent that we shouldn't?
Okay. Well, first of all, they're certainly rightly identified. These are questions of balancing and competing rights. And there are questions of privacy. But I guess probably because I've been immersed in this through the task force, it does seem to me that there are occasions, they have to be clearly established, where it's okay to invade somebody's privacy. If the action is so outrageous and the only way to hold them accountable is to in fact, find out through who the anonymous poster is. Now, that's a very difficult thing as well, because in terms of technology, all you can really find out is what computer sent this message. You can't, unless you've got, that raised big issues, cameras in and observing, then you're not going to know exactly who used that computer, but you can at least try it down there. But you're right, there are big issues, and in many respects, the internet itself has been a huge invasion of privacy. I mean, we'd all be appalled, an interesting exercise sometime, to Google your name and see all the information about you, good and bad, that is out there. The internet facilitates invasions of privacy in many cases, but you're right that in responding to negative things like defamation, bullying, and cyberbullying, we can't completely destroy privacy. I mean, I'm cynical enough, but I'm not this cynical. One person said, I forget where it was, but the context, but the quote was, "Privacy's dead, get over it." And one of the interesting things, again, being immersed in this task force, and this is not statistically supportable, but I think younger people accept much more being in the public domain and are less attached to privacy than us older adults are, that we're still pretty attached to privacy, and they are too. But I mean, just as an example, the statistic I gave earlier that 1 in 5 young women are sending nude pictures. Well, they aren't overly concerned about privacy, I guess, right? So that I think there's and this is not to take away from what you're saying. I think privacy is a really important value that we need to keep. But there are differences based on age and others, and I guess one can seriously question, and many do, whether the law could ever really regulate speech or privacy. Is the internet and social media the great wild untamed frontier? And whatever law is going to do, we're just not going to catch up. But I don't think we should just throw up our hands. But it is a delicate balancing question. I guess my own personal view is, at the moment, in my view, schools are erring too much on the side of privacy protection and not enough on accountability. Any other questions, or are you all exhausted? Okay. There.
Wayne, do you mind if I ask a question?
No, go ahead.
Wayne,
As long as it's not about wool socks or anything.
No. You had talked about freedom of speech. I mean, we have freedom of expression in Section 2 of the Charter, as you well know. But again, that's curtailed by Section 1, the Reasonable Limits Clause. Mm-hmm. And I'm thinking about the Keyster case that involved, of course, the teaching about the Holocaust, that it didn't happen, and so on. I'm also thinking of the Andrews case, which you're probably familiar with. Mm-hmm. And when the Supreme Court was making its decisions in those cases, they looked at what was a reasonable limitation prescribed by law as can be demonstrably justified in a free and democratic society. Mm-hmm. And they gave, as I recall, interpretation to that, Section 1, which would curtail that freedom of expression in Section 2 of the Charter, in the Oakes case. And what we say, I mean, we can't say what we want. In other words, our rights to freedom of expression are not absolute. They're subject to those reasonable limitations prescribed by law as can be demonstrably justified in a free and democratic society. So what somebody says on the internet, the social media, and so on, is it what they say defensible in terms of the goals and values of a free and democratic society? Is it actually promoting and achieving some either important governmental objective or societal objective? I guess what I'm saying is, if you can't find them because they're anonymous, is it possible, has any thought been given, I mean, is it ambiguous to go and look at this internet service providers that allow this sort of thing to happen? Can you comment on that?
Yeah, no, a really important point, and I think I'd mentioned in passing that we suggested a protocol between police and internet service providers, but that's a big area, and internet service providers do have an obligation and a role to do some policing, the same as newspapers and others do, of what content they distribute. And so I think that's true. One caution on the sort of role of the Charter in all of this, of course, the Charter only applies to government actors. So one of the, and hence the importance of human rights codes and other things, that a lot of this would be private statements, so that there's that limit. But once you do get Charter application, then you're absolutely right. The courts have recognized reasonable limits in areas like hate speech. The other caution about that, and I think this is still correct, there's only ever been one successful criminal code hate speech prosecution in Canada, Keyster. no other case. Others have been raised, and some went and then got overturned. But I think this is still right, that notwithstanding that, yes, they can do that balance, and notwithstanding Judy's point that Canada is not quite as free speech obsessed as the U.S., that there's only ever been, the Keegster case is the only successful prosecution for hate speech. And as I say, significant side point, that now federally we have removed from the Canadian Human Rights Act the sort of equivalent, less serious sanction for hateful or discriminatory speech. So you're right, but it's a difficult, as always, a difficult balance.
Can I throw another question out?
Sure.
Do you think it's reasonable to hold the carriers accountable, not just in terms of access for privacy to find out who's posting defamation statements or defamatory statements or hateful speech, but not just to get access to the information, but to also hold not only the person who posted the information, but the carrier who distributed the information? Do you think we'll get to the point in legal jurisprudence where that will be part of the objective as well in terms of accountability?
Well, I mean, an interesting question. Can we hold the internet service providers liable for distributing, even short of giving access and so on? And I think that's something that needs to be looked at in terms of the hard copy media like newspapers. That's already there in terms of things like defamation. The challenge is, you know, let's take something like Facebook or Google or whatever, but let's take Facebook. The extent to which they could actually police that would be very difficult, but still worth pursuing, I think, as one thing to think about. Now, the other question about that, I guess, is the extent to which, again, when you're talking charter, they're not subject to the charter. But there's other ways, legislation. And I think that's really, again, back to that message. I think given the scope of the problem, that we need to be more adventurous and creative in thinking about that kind of legislation. The Consumer Protection Act, should we have more in there? That website I referred to earlier, the dirty.com, where you can find out whether you're there or not. I think this is right, the way they operate, if you contact them, they'll take it down for a fee. So, you know, kind of a clever, but not very desirable way to do business. And the other thing is there are simple responses that sometimes people don't think about in terms of Facebook and YouTube and those kind of things. If there is something offensive, very often if you contact, let's take Facebook, and ask them, without a fee in this case, but if you ask them to take it down, they usually will, not always. And we've had a very high profile example of that, right, recently with the outrageous Luca Magnotta case, where the YouTube video of him killing and cannibalizing his roommate, right? That was up on YouTube, and lots of people have said, should they, or I'm not sure it's YouTube, some site, was that acceptable? And they were contacted and took it down. And I think this is right. I read in, I think yesterday's Globe and Mail, I think it was, that some teacher gave in to the pressure of his students to show that YouTube video in class, and is now being investigated as to whether that's conduct on becoming a teacher. But it seems to be, that's living a bit on the edge, I would think. But in any event, and did at least ask if anybody didn't want to see it, they had the right to leave, but nobody left. And he did show the video. Now, part of his rash answer to that was, well, they're going to see it anyway, so at least we can do it in a structured setting. Anyway, he's, I'm not sure exactly where it is, but he's now being investigated before the teacher organization. So anyway, one example of the complications. All right, not seeing any more, and it's lunch awaits. Thank you very much for your attention, and thanks for coming.